On this morning's Ag Issues program, a pleasure as always to bring to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Well, we have come up to, and as we mentioned earlier, this time of year, we normally look back at what you consider as some of the top 10 developments in ag law and tax during the previous year, in this case 2022, and we've hit the top 4. And I'm kind of curious, from your perspective, since that you make the list, how do you look at the criteria of on how to rate this?
Well, really, my criteria is what is a development that affects most broadly the agricultural industry in terms of production agriculture, as well as agribusinesses and retail businesses, basically the sector as a whole, all across the country. And so often when we get clear to the top end of the list, it's going to be some type of national regulation, a federal regulation. It's going to be a Supreme Court case. We're done at this point in time when we get this far up the list with state developments, although there were some state developments that I've had in the top 15 or 20, and even maybe at the bottom of the top 10, because of their significance in that state that will likely carry over into other states and other parts of the country, and it has implications that other legislatures and other courts will look at. But when we get this far up the list, it's going to be a major development with broad application all the way across the country.
All right, let's get right to it. And at number 4, this is a decision that came early or a policy that came in early last year, that of course being the EPA announcing a new policy regarding its Endangered Species Act responsibility under FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act.
Yeah, that's one aspect of what EPA did with the Endangered Species Act. There are some other things that were done by other federal agencies that have direct responsibility for the for the Endangered Species Act, ESA. And this is a big issue for private landowners. I don't think unless you're in agriculture or unless you own rural land, you really probably don't have a feel for how much of that privately owned land in this country is subjected to the Endangered Species Act because there's some type of habitat, whether it's a plant or whether it's an animal or amphibian that has habitat on their private property. And if that's the case, then your agricultural activities on that land can be severely restricted. Years ago, Greg, it was probably 25 years ago, we had issues in Kansas with the Topeka shiner. We're now dealing with the Endangered Species Act with respect to a bird in Kansas that's got, pardon the pun, but it's got a lot of people's feathers ruffled on that one, and we've gone through that with the grouse before. But the federal regulators did a couple of things in 22. That now the EPA put out a policy plan focusing on mitigation effects on threatened or endangered species under the Endangered Species Act when it also involves pesticide registration reviews. So we know agriculture uses a lot of pesticide. Now there's kind of this overlapping and overarching regulation between ESA and FIFRA. And that's going to be something that's going to be a big issue for farmers moving forward. Other things that were done throughout 22, there were other regulations under the Endangered Species Act that were either changed or modified. Many of those, when I look at those, will potentially negatively impact ag activities on private land. For instance, one of those, habitat, is no longer specifically defined. They just simply removed the definition of habitat and made it, on a case-by-case basis. We're going to determine whether this particular species has habitat in this particular area, which makes it very difficult, again, for a landowner, a farmer, or a rancher to understand whether they're being regulated or not. You kind of are going to get caught into this regulatory web and administrative web of trying to figure that process out. And what was known as the critical habitat exclusion rule was rescinded. So that'll make it easier for the Fish and Wildlife Service to designate critical habitat for protected species under the Endangered Species Act. And again, a lot of that's on private property. There are a couple of other things that were done. The blanket rule, so-called blanket rule, was eliminated, and so now they're lumping threatened as well as endangered species all together. I think that is contrary to the statute, but that's what they have done. And the rule was still in effect during 2022. But that's going to be changed, and so that's what they were working on in 2022. I would say those are the big ones with respect to the Endangered Species Act. Obviously, it will have more of an impact in other parts of the country as opposed to Kansas. There aren't that many listed or threatened species in Kansas, but you get into places such as Texas and Florida, California. That's where the majority of these protected species are at, and it really does impact agricultural activities. We see stories in the news, the non-legal news, just the general media, where certain types of farming practices or brush removal practices, for example, out in California, can't be done because there was some type of jumping mouse or kangaroo mouse that had its habitat there, and so now we can't do any fire prevention control out in California, for instance, and so or we can't till a field in New Mexico because of some protected rat species, which actually happened, and so you'll continue to see those stories, and I think probably on an increasing amount as we go forward.
Another part of this, number 3, of course, is what we have seen and what has affected many people and in agriculture as well. Mm-hmm. And that's, of course, is economic issues impacting daily decision-making for farmers and ranchers.
Yeah, we've really got, I think, some really tough headwinds for the general economy in front of us. Things are not great right now, but the numbers don't look promising for in the future. We've got price inflation. Of course, that was triggered by policies that increased the price of fossil fuels from basically the beginning of the current administration. And once you have price inflation, that gets into everything throughout the economy. And we've had other policies that have created wage inflation. We've had massive deficit spending. We've had poor policy choices by the Federal Reserve for a very long time that kept interest rates at artificially low levels, which further increases demand and increases inflation. And so during 22, they started to pull back from that policy and increased interest rates to decrease demand and reduce inflation. So they're trying to find a soft landing to this inflation that's been going on in the economy. I don't think that's going to happen with the current policy. For those old enough to remember, Paul Volcker is not in charge of the Federal Reserve right now, and we need a Paul Volcker instead of a Jerome Powell. I just don't have much confidence in Jerome Powell being able to navigate to a good landing as to where we're going. And then in 22, we had further deficit spending by the Congress with the green energy bill that was enacted in August. It was known as the Inflation Reduction Act. But that's going to largely offset a lot of the impact of the Fed's interest rate increases. And that was what we were seeing at the end of 22. And so now we've got the Fed going to continue to increase interest rates. Well, that in and of itself has an effect on short-term financing for farmers. You go to take out your input loan to buy your inputs to put crops in the ground this year, you're going to do so at a much higher rate than was a year ago or 2 years ago. That's okay if you get that loan paid off. But for those that are struggling and have financial issues, then you've got the debt issue that's out there with respect to farmers and ranchers. So interest rates going up on all of the political and economic choices, all of them have implications for farmers and ranchers in terms of crop production and the energy issues that are out there and our monetary policy and issues in the meat sector. And, of course, water issues as you get into western Kansas and points further west in the United States. And then, of course, there's always the unanticipated shocks to the system that can't be anticipated that will have farm-level impacts. And, of course, the war in Ukraine, the war against Russia that's being fought in Ukraine is who knows what that's going to do in 2023 with respect to global grain trade, and that'll create more issues for farmers. And what happens to world food output, and those are all unanswered questions that farmers don't have control over. So all of those things going into 2023 makes it kind of right now, we're kind of cautious, very cautious as to advice we give farmers and ranchers, estate plans, tax plans. It affects everything all the way to the bottom line.
As we review the top 4 developments in ag law and tax of 2022 with Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. Well, Roger, we're up to number 2, and this is an issue that we may hear about at the end of 2023 as it continues to roll, and that, of course, is California's Proposition 12.
Yeah, this will definitely be in the top 10 list for 2023 because this is a case that's presently before the U.S. Supreme Court. Of course, what we're talking about here is California, with Proposition 12, making the move to ban the sale of pork products in their state if that pork wasn't raised in accordance with California's standards. And those standards include gestation crates for sows where the sow can get up, stand up, turn around, and not touch any of the sides. Well, that's not the way they're raised in states such as Iowa, a major pork-producing state, and elsewhere, and for obvious reasons. But that violates California's standards, their morals, so to speak, out there, and they think that that's abusive to hogs, and so they don't want hogs raised that way. And if you do, you can't sell the resulting meat products. You don't have access to their market in California. Well, this is a rule, this is a law, a state law that has absolutely no impact on California pork production because there's virtually no pork production in the state of California. But their consumption market is 13% of the national market. So as a seller of pork, you want to have access to that market. So this is what we call in the law a 100% extraterritorial effect. And that's the question that's before the Supreme Court, that under the Commerce Clause or the so-called Dormant Commerce Clause, what is the extent to which one state can regulate the activities that occur in a different state? And the oral arguments on this back in October were pretty interesting, and the justices really got into quite a discussion about, well, what if Iowa, for example, wants to retaliate back against California? Where does this stop? And that's a really good question. So the justices wrestled with that. You could tell they were pretty hard on questions on both sides during oral argument, and I think they're trying to find a way to maybe thread the needle on this one to say, well, states, you can do this, but you can't do that. But whatever they say, this is going to have major ramifications, not only for agriculture, but we think of all types of other markets for various types of products, ag and non-ag. And again, the question comes down to how far can a state go in regulating those out-of-state activities? And that's the key question that we're going to have to stay focused on.
Because this potentially could have a very, very long tail, as you mentioned. It's almost to the point you say, what could be next? Right.
Yep, that's exactly correct.
All right, let's get to the number 1 item that you consider as the top development in ag law and tax of 2022. And again, we go back to the Environmental Protection Agency, their regulatory authority under the Clean Air Act, or in this case, the Major Questions Doctrine.
Yeah, this is a U.S. Supreme Court opinion that came out near the end of the term, last term in June, and it's a very, very important case because it totally, I think, corrects the administrative state in this country, the federal administrative state, and perhaps there'll be trickle-down effects through state level too. And the question, yes, it involved the EPA and the Clean Air Act, but the impact of this is much broader because the U.S. Supreme Court basically said, well, they didn't basically, they said it, invoking what's known as the Major Questions Doctrine, and that is when an administrative agency takes it upon themselves to change the entire law that governs a particular subject matter on a national basis. That's not their domain. And that is the domain of the Congress. The administrative agencies have the responsibility to carry out a statute that Congress enacted, but they can't set policy themselves. And that's what the EPA was doing in this. It started with the Obama administration and his promise to establish policy, in his words, that would bankrupt the coal industry. And so as a result of that, his instructions to EPA were go out and regulate CO2 emissions from coal and natural gas-powered plants under Section 111 of the Clean Air Act, and put draconian limits on them so they can't function. Well, this case got into this all the way up to the Supreme Court and said, look, EPA, you can't shift energy generation at plants to renewable sources such as wind and solar by doing that. I mean, you have the authority to say that with existing structures, you can do this and you can do this. This is how you come into compliance with what the law is. You may have to put scrubbers on, these types of things, the regulations that are necessary to carry out the statute. But there wasn't anything in the statute because Obama knew he couldn't get it through the Congress. So he tried to do it through the administrative agency. And the court said, no, that's not the role of the administrative state. That's the role of the Congress. This is in my view, a very good opinion. It sets the lines very clear between the executive branch and the legislative branch and the administrative state. And you got to stay within your lines, stay between the lines in terms of what your job is. And that is a very, very important opinion. There are so many ag activities that are subject to federal regulation as well as state regulation. And it's important for the regulators to stay within the bounds of what the policymakers want them to do. And that's what this decision did, and that's why it's at the top of my list.
And you talk about, we talked about Prop 12. Well, it will be in the top 10 there. I mean, you've got cases pending that you definitely know, from your perspective, will be in the top 10 once we get the decisions handed down.
Yeah, the Sackett case is still out there. That's the one from Idaho involving the definition of what a water of the United States is. And, of course, we've got, in that instance, again, the administrative agency, in my mind, jumping the gun and coming out with a final rule before the Supreme Court has issued its opinion in Sackett, which could wipe out that rule. That's going to be on the list over this next year. Of course, the economic issues are going to continue to loom large as that impacts agriculture in 2023. And so we've got a lot of issues that are going on, and we're going to continue to have a busy year in ag law and tax throughout 2023. And we're going to have a pretty robust list, I would guess, by the time we get to the end of 23, and you and I discussed this at the start of 2024.
And, Roger, if people want to see your list and all the developments that we have talked about here in the past several programs, what's the best way they can do that?
I've done multiple blog articles on this throughout January on these topics, probably 5 or 6 different articles where I break them down 2 or 3 at a time. And that's on my website, washburnlaw.edu/Walter, WALTR. You can also find them on KSU's Ag Econ Department Ag Manager website. So they're all posted there, too.
All right. Sounds good. Well, Roger, as always, appreciate it. And we will talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.